Thank you, Kyle. We're going to be talking about special needs planning in Colorado because Colorado does have some very specific Colorado-only laws and regulations that you need to know about. Now it's not. Let me see here. Okay, there I am. I just want to let you know that I co-authored a 2-volume treatise on special needs planning for the California Education of the Bar, and I co-founded the Academy of Special Needs Planners. Those of you who practice in this area will have heard of it. It's one of the 2 or 3 national organizations for special needs planning attorneys. But I won't go over the rest. There are basically 3 types of special needs trusts plus ABLE accounts, which kind of work like special needs trusts. So there are third-party special needs trusts. These are these are estate planning special needs trusts and gifting special needs trusts. Then there are disability trusts. That's what Colorado calls them. Anywhere else, you'll hear them referred to as first-party S&Ts, D4A S&Ts, or sometimes OBRA S&Ts. And the OBRA and the D4A refer to the laws under which they were passed. And first party refers to the fact that it is the beneficiary's own money that is going into the disability trust. So that's the big difference between that and the inheritance and gifting style trusts. Here, we don't have money from someone else. We have the beneficiary's own money. And then there are pooled trusts, which are similar to disability trusts in that they take the beneficiary's own money, but they are pooled together with other people's special needs trusts and managed as a whole. We'll talk more about all 3. And then at the bottom, not a special needs trust, there are ABLE accounts. Now, ABLE accounts allow the beneficiary to access the account for certain qualified disability expenses, and we'll talk about what those are. But you can only put in $17,000 at a time. It can be the beneficiary's own money, or it can be a gift. But that's the eye of the needle that you have to fit through. Only $17,000 per year can go into an ABLE account. So now let's talk about third-party special needs trusts. These are the kinds of trusts that are created in the estate planning attorney's office when the parents are planning for their child, or sometimes a grandparent creates a special needs trust for a child. A third-party trust is for any beneficiary who is or may become eligible for needs-based government benefits. So this could be developmentally disabled children. You don't know if they're going to need public benefits when they turn 18, but they might. Mentally ill teens, again, you don't know how successful their treatment will be, but if it's not as successful as you hope, a special needs trust might help them. And physically disabled people, could be adults. A third-party trust can be created for anyone at any age by anyone else. It just can't be created for the beneficiary's own money. And you're thinking, well, how would a developmentally disabled child have much money? Sometimes, especially physically disabled adults, were disabled because of an accident, and that results in a personal injury settlement. That is the beneficiary's own money. We'll talk about some other forms of the beneficiary's own money. Now, with a third-party trust, the beneficiary does not need to be found to be disabled by the Social Security Administration. You'll see that's a requirement for disability trusts, but it's not a requirement for third-party trusts. There is no technical requirement for third-party trusts, But in my office, when I'm meeting with clients, the test is that first bullet. Is this child usually potentially going to need government benefits? Third-party special needs trusts were created by common law. They're not creatures of statute, unlike the others. The grantor of the trust can be anyone except the beneficiary. The trustee can be anyone except the beneficiary, including the grantor. It can be funded by anyone except the beneficiary. And there is no minimum or maximum. We'll talk about trustees, and trustees do have minimums and maximums, so that might affect it, but there's no minimum or maximum under common law or by statute. If there is a remainder at the end of the beneficiary's life, it goes to whomever the grantor chooses, and the grantor can give the beneficiary a power of appointment if they're competent to handle that. So, none of it goes to the government. Now, the old-fashioned way to deal with a child who's going to need needs-based benefits is to disinherit them. And I still see that sometimes, not very often, but I still see that. Disinherited, the child is purely restricted to what the government chooses to give disabled and low income people. And that changes with the political winds, it changes with budgets, it changes with state budgets. So that's not a very nice life to consign your child to. It would be better to leave it directly to the child without a special needs trust so that we can create a special needs trust post-mortem. So never disinherit a child with special needs. Always leave it to them, even if the parent doesn't want to create a third-party special needs trust. Because after they're gone, we'll create a first-party special needs trust, and the child will be okay. I do want to mention another source of income, and that is child support. Typically, with a disabled child, child support continues past the age of 18. And once the child turns 18, that child support is considered an asset of the child's or income of the child's. So that money needs to go into a first party special needs trust, not a third party special needs trust. Now, the parents may still want to create a third party special needs trust for their own estate planning purposes. If it's an amicable divorce, they could share one. If it's not amicable, they could each create a third party special needs trust. So in that family, you would have three. You would have the first party trust for the child support, the third party trust for dad's estate planning, and the third party trust for mom's estate planning. Oops. Okay, now we're going to talk about disability trusts. These are those D4A, OBRA, first party trusts that you saw on the first slide. They can only be created by certain people, and that's because they are creatures of statute. They can only be created by the beneficiary. Originally, when they created this law, they did not include the beneficiary, which was a real problem for beneficiaries who had cognitive competence. The Congress seemed to be assuming that anyone with special needs was incapacitated, and couldn't understand creating a trust. But they went back and changed that just a year or two ago. So the beneficiary can create a first party special needs trust. Their parent or grandparent or legal representative, like a conservator or guardian, can create a first party special needs trust. The only money that can go in there is the beneficiary's money. And the first tight restriction is the beneficiary has to be found to be disabled by the Social Security Administration. So it's not enough that they seem pretty disabled, that you have to have a letter from the Social Security Administration saying, you have been awarded SSDI or SSI. We'll talk about those. Because you are disabled. They have to have that letter, and you have to have a copy of that letter. So I hope they saved it. There is a way around that if they don't have a copy, but it's time consuming and unpleasant. So the Social Security Administration standard is what you see in italics there, unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. So if the beneficiary is receiving Social Security disability income or supplemental security income, they have received that letter, and it's just a matter of finding it. Now, Social Security disability income is income a beneficiary who is disabled before the age of 22 is entitled to based on their parents' work record when their parents retire or die. So if their parents are still working, they will not get Social Security disability income. If one parent is retired, they'll get it off of that parent's record. Supplemental security income is what disabled people receive when they don't get SSDI. It's under $1,000 a month. SSDI can be much more. And SSDI comes with Medicare, which is a much better healthcare situation than Medicaid, which is what you get with SSI. This is not talk about public benefits, so don't worry if you got lost somewhere in there. Call me. Now at the bottom, please note it says Medicaid gets paid back from the trust remainder. So this is very different from a third-party trust. Right now, the regulations say Medicaid is paid back for what they spend on a beneficiary who is over the age of 55. So Medicaid will not get paid back for all of the services they provide under that age, under current regulations. Those are subject to change. But if the beneficiary lives past 55 and is still on Medicaid, when they die, Medicaid will place a lien on the estate for the amount that they spent above the age of 55, and that lien will have to be paid first. Taxes are the only thing that comes out before that lien. Disability trust in Colorado, that's Colorado's term, and then I gave you the full site for the federal statute that creates special needs trusts. That should be, yeah, that's all right. Yeah, that's right. All disability trusts have to be approved by the Department of Healthcare Policy and Financing. That is not the case with third-party trusts. The department does require you to send a copy, but they have no approval power. You just send a copy in and you're done. With disability trusts, you have to get it approved by them, and that may take a couple of rounds. You submit the trust to that email address you see on your screen, and that trust had better contain all of the Colorado specific provisions that are required under the regulations, and I'll give you that site. Unfortunately, DHCF agents are not always aware of the latest changes to the regulations, and they may reject your trust and demand that you put in a provision that is no longer required or that has been altered. So then you have to kind of fight with them. The wait times for a response are 1 to 4 months. That's at least that's what I've experienced. And I recommend you follow up if you haven't heard back after 2 months, because they do sometimes lose them. And that's at any stage, either after you've submitted it or after you've submitted changes or after you've submitted your letter arguing why you don't need to make a change. Follow up if you haven't heard back after 2 months. Pooled trusts. Pooled trusts, as I said, are common entities. In Colorado, ours is run by the Colorado Fund for People with Disabilities, CFPD, and their website is cfpdtrust.org. The way a pool trust works, or let's just use Colorado's, CFPD set up a trust. They created a D4C trust. That's the statute it's under, that 42-1396 D4A. This is D4C. So they created a D4C trust. And what you can do, or your clients can do, is join that trust. They can't have any custom drafting. There's nothing for you, the attorney, to do other than refer them. And they deposit their money and sign a joinder agreement. CFPD charges a percentage. I think, we've got a question called, will the PowerPoint be available after the Zoom?
And I will send that out once I receive it from Deidre. I'm hoping to receive the CLE form as well, because that's a little delayed, but regardless, I'll send out the PowerPoint as soon as I get it from Deidre this afternoon.
Okay, thanks. So CFPD, they have different fees. They also will be trustees of first-party trusts and third-party trusts. So you might want to contact them and learn about their fees, but they reach as high as 3% of the trust assets per year. And I believe they have a minimum of either 250 or 500 in fees. So even though they're probably the most cost-effective, for a really small trust, you probably want to look at an ABLE account. Okay, so I've got the code site for you, D4C. The trustee is always a nonprofit organization. The assets are pooled together in one investment account. Separate ledgers are kept for each client, and at the end of the client's life, the remainder goes either to the nonprofit, which is what we have in Colorado, or to Medicaid if the nonprofit hasn't set it up so that they receive the funds. And then you've got their site. Let's talk about ABLE accounts. So ABLE accounts are really for beneficiaries who either can handle it themselves, like this smiling young lady, or who have a conservator or a power of attorney who can handle things for them. There's no trustee of an ABLE account. It was established in 2014. And the reason it's called ABLE is that acronym of Achieving a Better Life Experience. The beneficiary must be entitled to benefits administered by the SSA. So that means supplemental security income or Social Security disability income before the age of 26, or they can have a disability certification filed freshly with the SSA each year. Why would you use a disability certification? Well, it's primarily for beneficiaries who meet the Social Security criteria. They would qualify, but there's something stopping them. For example, their application is pending, or they have too much money, or they qualify for SSDI, but their parent is not retired or disabled. So disability certifications are not used much, but they're available for you. You can only put up to 17,000 in an able. I think that'll go up to 18,000 with the gift tax exemption next year, but I'm not fully sure about that. I think it's tied to the gift tax exemption. You can only have one able account. And there's a further limit. It's the lesser of 17,000 or the beneficiary's gross income or the poverty limit. And the gross income includes any public benefits. So if you have a beneficiary who's really receiving nothing and has no gross income, you can't use an able account. Okay, now even though it's only 17,000 per year, you can pile up to $200,000 in there. The account is owned by the beneficiary, and it was designed to be a savings account for people with disabilities. Congress said, you know, why should people who are on such a tight budget with only public benefits to live on, why should they not be able to save and have a little bit of a cushion for themselves like other people? So that's what the able account was designed for. The beneficiary may get some investment choices. They'll all be conservative. It receives tax advantages similar to 529 accounts. So if it's withdrawn for qualified disability expenses, there is no tax on the income it earned while it was in the able account. You can't put anything but cash into an able account. You can't put a house into it or stocks. Maybe surprisingly, you can change the beneficiary of an able account just like a 529 account. So if one beneficiary recovers and there's another disabled family member or even a friend, you could change the beneficiary of that able account to them. In Colorado, you would establish it with the Colorado Fund for People with Disabilities. And like the pooled trust, Medicaid or the nonprofit is paid back from whatever is left in the able account. So if you can't change the beneficiary, Medicaid or the nonprofit gets whatever's left. So let's talk about qualified disability expenses. These are the only expenses that are allowed to be withdrawn from an able account. Any expenses related to the individual's blindness or disability, which are made for the benefit of an eligible individual who is the designated beneficiary, including the following: education, housing, transportation. And the housing one is really nice there because normally if a distribution is made for housing, it reduces SSI by 1/3 or up to 1/3, but practically 1/3 every time. For food or housing, it's reduced by 1/3, but not if it's coming out of the able account. So employment training and support, assistive technology, personal support services, health prevention and wellness, financial management and administration, legal fees, expenses for oversight and monitoring, funeral and burial expenses, and other expenses approved by the secretary. So the secretary has only approved one other category of expenses, and that is food. So now food and housing can both come out of an able account and not reduce SSI the way they would if they came out of a special needs trust or a gift from a parent or someone like that. Drafting special needs trusts. Just check the chat, make sure there are no. Okay, no more questions. Drafting special needs trusts. So here's the process you go through when a client calls you up and says, there's, you know, I want, I have benefits and there's money coming in. So first, is the amount under 17,000? If yes, go to the ABLE account. It's just not cost effective to create a special needs trust and pay a trustee and have a separate investment account. Just go with the ABLE account. If it's not under 17,000 on the left, your next question is whose money is it? If it's the beneficiaries, you go with a disability trust. If it's not the beneficiaries, you go with a third-party special needs trust. So this is just the same thing in words. There are a few more notes. When you do a disability trust, you have to make sure you've got someone who can establish it. If the beneficiary is not competent and there is no parent, grandparent, guardian, or conservator, you'll have to either get a guardian or conservator appointed or petition the court to establish the disability trust. The court is authorized to establish disability trusts. Sorry about that. I've got a dog. Let's see. So I've got a note at the bottom of the page. If the money is an inheritance, or a gift that has already been completed, then it is now the beneficiary's money, and you have to go back to a first party trust, not a third party trust, the way it would have been had the parent or grandparent created a third party trust while they were alive. So I have a question from Jennifer. Who would be the trustee if the court created the trust? The court would appoint a professional private fiduciary from their list. They would just pick whoever is next on the list, and that would become the trustee. And those folks typically charge an hourly rate for their work, somewhere between $75 and $200. The one we work with for third-party special needs trust that we really like charges $150. And the court-selected ones are probably less than that because the court is very sensitive to the costs to the beneficiary. Oops. Choice of trustee. So you have the same choices you have when you create a revocable living trust or any other trust. You've got, Bank of America and Fidelity's trust department. You've got Midwest Trust. I do want to highlight Golden Fiduciary Services because they are a trust company in Boulder that focuses on special needs trusts. They can handle a client's entire estate plan, meaning they could be the backup trustee for a client's revocable living trust. If the client also has a special needs trust somewhere in their plan. So their focus is SNTs. They have a ton of experience in S&Ts. You can ask for Christopher Scantz and tell him I sent you. He's the head of handling S&Ts, the head of the division in Boulder. And we'll answer any questions you have. They charge a percentage of the assets to be the trustee, and they do have a minimum. I think their minimum is $250,000. And I think the percentage of assets is, it's based on the amount of the trust. Then you have professional private fiduciaries. And I mentioned contemporary fiduciary services because I want to put a good word in for Crystal Woodbury. She's done a great job for our clients. You can Google her. So professional private fiduciaries are people or companies that act as professional trustees. They're not licensed in Colorado, although in some other states like California, they are licensed, so that may be coming. And typically they charge an hourly rate and outsource the investing of the trust. And then there's a private individual. The trustee can really be anyone. It can be the grantor. It can be a sibling, although be careful with that because sibling rivalry is an issue, and siblings, especially older siblings who were not disabled helped raise that disabled child in all likelihood. So they probably feel a sense of responsibility, but they may also feel some resentment. So make sure your clients are honest with themselves about that before they choose to name a sibling. The trustee of an S&T when the parents divorce. Usually they have very low trust of each other. A co-trusteeship with husband, ex-husband, and ex-wife is very rarely successful, but in Boulder with a couple of hippie parents, probably would work. You just have to make sure they're working out everything else, like child custody and child support, smoothly. If they're having problems with those issues, they're going to have problems being co-trustees of a special needs trust. Since it makes more sense for just one spouse to be the trustee, so they don't have to pay an outside trustee to do it, I would recommend it's the spouse receiving the child support. Otherwise, you're giving full control over how that spouse spends the support to the spouse who's giving the child support, who would love to have full control, but the spouse receiving it does not want to have to ask them for every single thing they buy. So I think making the paying spouse the trustee is a very bad idea. Making the receiving spouse the trustee can work really well. But if that doesn't work, I would say a professional private fiduciary, a trust company, a trust department, something like that. Okay, so now let's talk about what it's like for a private special needs trustee, not a professional private trustee, just a sibling or a child or a sister or brother of the grantors. They'll need assistance. So as the drafting attorney, you'll have to counsel them on how to stay in compliance with the state's Medicaid authority for their Medicaid benefits and with Social Security for their SSI or SSDI. It would be great if you could counsel them about Section 8 and SNAP, but personally, I don't go that deep into public benefits. I stay at the level of the most important ones, Medicaid and SSA, and I rely on care managers and others to apply for and get the benefits from other programs. Now, a special needs trust, just like any other trust, has an accounting requirement. So unless the trustee is a bookkeeper or accountant themselves, or really good with their own personal finances, it might make sense to hire an accountant and then have those accountings reviewed by the drafting attorney before they are submitted to the legal guardian or other people who are entitled to them, like the Department of Healthcare Policy and Finance. A care manager, there are kind of two types of care managers. One type of care manager is much more on the medical side. They're more like a medical advocate, and they will make sure that you're receiving the best possible care for your condition. And then the other kind of care manager is more like a benefits manager, and they will help the beneficiary obtain all the benefits that they're entitled to. And they will advocate for the beneficiary if they are turned down for any benefits. If even that doesn't work, they may come back to you, the attorney who referred them, to handle the dispute from there. So care managers are great, and it's great to have one on board. Now, for the first party and the third party special needs trust, you can give custom instructions. You can't do that for the pooled trust, although you can leave a letter or memorandum of intent. It's just that the trustee may not follow it as closely as the trustee of a first or third party trust would. Because in a first or third party trust, you can put in language that says, so long as it does not cause a problem with public benefits, any memorandum of intent should be followed by the trustee. And you need that so long as language, because the memorandum of intent might say, pay for the child's shelter, and boom, they're not eligible for Section 8 and they've lost 1/3 of their SSI. And if it instead says, so long as they don't reduce benefits, then that doesn't happen. So a memorandum of intent should be written by the parents. We provide our clients with kind of a checklist of things to consider, and I've got some things on here for you as they draft it. And when they do draft it, we recommend they let us review it and make suggestions, just in case they have said something on there that would cause public benefits to be lost. And there's a private trustee who doesn't know better. We'd rather head that off at the pass. So some of the things we suggest parents do is review it and update it annually. Include contact information and a description and name for all of the people that keep the child working, functioning. They're all their doctors, all their therapists, their physical therapists, their occupational therapists, their speech therapists, whatever therapists they have, any contacts the parents have with local benefits agencies, like if there's a Social Security representative they've been working with, and contact information and relationship info for friends and family who would be willing to help if needed. We're not talking about friends and family who would be willing to take over as trustee, although they may also be that. But no, this is just friends and family who would be willing to help advise the trustee if there's a question. Should this child receive this controversial treatment? Should we pay private college tuition for a child that we're not even sure can handle a semester? Or should they go to community college first? They got in. What do you think? So things like that. It's great to include a list of triggers that can cause distress in the child. My brother, who has pretty severe autism, cannot stand dogs barking. And when he comes to our house, he wears those big helicopter headphones, so he can't hear anybody, but he also can't hear that dog barking. He also hates loud mufflers, like when a car backfires. So those are, if you include that list, it'll help a caregiver understand, why is he screaming all of the sudden? Oh, it's that car that just backfired. And include some ideas for how to soothe the child. Now, obviously, I'm talking here more about parents than I am about, say, an adult beneficiary who was paralyzed in a car accident and is doing all of this for themselves. They're not going to do a memorandum of intent. Include a list of favorite pleasures and attach all the treatment plans and evaluations that the child has ever had. Put them in the estate planning binder, or make a separate binder for the special needs trust if they won't fit, but put all of those in there. It's the child's medical history, so it's important. Now, your firm, what should your process be? So the initial contact with your firm may be made by a beneficiary or someone caring for them, like a parent. It may also be made by a personal injury attorney who has a client who is disabled and is about to receive a bunch of money and who is on Medicaid. Your first job is to determine who's the grantor, because that's your client. You have a fiduciary duty to that beneficiary, but the grantor is your client. So that's the person whose money is going to be going into the special needs trust. And that's the person who needs to be included in all the meetings. And that's the person who needs to approve the special needs trust. So encourage them to include the beneficiary and potentially the trustee in meetings. It would be most appropriate to have the beneficiary in the design meeting, only if they're old enough and competent enough. I mean, they shouldn't be pressured to think about their mortality if they, are a 13-year-old with depression. That's not a good idea. So, include adult beneficiaries or mature enough beneficiaries in the design meetings. Consider including the trustee in the signing or document review meeting so that you can explain the trustee powers and the trustee administration provisions to the person who's going to actually have to follow them. Use a certificate of trust aggressively to keep that special needs trust confidential. It's very sensitive. It has HIPAA information in it, although you are not covered by HIPAA by virtue of doing special needs trusts. You're not subject to those rules, but be sensitive. So if there's a real estate transaction, attach only the trustee powers article to a brand new certificate of trust. That should satisfy the title company. If it doesn't, attach the administration article. They don't need to see the distribution article. They never need to see that. And they don't need to see any articles that describe the beneficiary's disability. Okay. So some design tips. Include provisions that encourage the trustee to pay for specific things for that beneficiary. Things that beneficiary in particular wants. Now, you'll probably have some kind of initial S&T form you're working from, and it may have a list of examples. It should always say these are included but not exclusive. And then add to those examples things that are really important to that beneficiary. Consider acting as a trust protector. If there's no trust protector, if they don't want that or you don't want that, consider giving the trustee the power to make limited administrative benefits eligibility and tax law modifications to the S&T. If you draft it narrowly, it will not cause the trustee to be a grantor. And you really need one or the other because you're going to sign it and then it's going to go to the Department of Healthcare Policy and Financing, and they may come back with things you need to change. If a beneficiary establishes a D4A, they sign as grantor. For disability trusts, at the very bottom, I've given you the site to all of the regulations about what has to be included in a disability trust and what can't be included. So that's what you're going to follow before you finish that trust for DHPF. So that's for first party trusts only. Okay, questions and answers. We've got just a few minutes left. I see I've got one in the chat from David. Does a fully discretionary third-party trust satisfy third-party S&T requirements as long as the trustee exercises the discretion to not adversely impact benefits? Yes. you can use a fully discretionary standard. In other words, the trustee can distribute for any purpose, even a purpose that would cause a loss of benefits, if the trustee determines that is in the beneficiary's best interest. Now, you want to include some language that the trustee should not distribute for things that will cause a loss of benefits unless there's no other alternative, or unless the trustee has determined this is the best option. But that is precatory. The distribution standard is fully discretionary, and the problem only happens if the trust is distributed for something that does impact a benefit. The standard won't cause a problem. It's just the distributions that could potentially cause problems. Can an intentional distribution cause only a temporary loss of benefits? Yes. Typically, benefits are only lost for the month in which the disqualifying distribution is made, unless the beneficiary keeps those assets, those disqualifying assets, in their name month after month after month. Then they're going to be, say they get $3,000. Medicaid says you can only have $2,000. So if they got $3,000, it would be income in the month of receipt, which would disqualify them for their SSI and their Medicaid. And if they spent it all, they'd be fine next month. But if they didn't, if they held on to that $3,000, they're disqualified the following month as well. I hope that answers your question. On ABLE accounts, you said that to apply, income was the lesser of $17,000, or the beneficiary's income, or the poverty level for the state and year. I'm not sure what the exact legal phrase for it is, poverty line, poverty level. The poverty line that's determined for Colorado. That's the third thing. Yeah. Any other questions? I hope you guys all have a great time working with this community. The special needs community is very satisfying to work with, because you know you're helping people who can't help themselves. Thoughts about putting a residence into a third-party special needs trust? That's a great question, because if you distribute for food or shelter, you lose 1/3 of your SSI. So if the beneficiary is not receiving SSI, if they're getting Social Security disability income, they'll never need SSI. And what I'm about to say doesn't matter. This only matters for beneficiaries who are receiving SSI, and their Medicaid might be tied to their SSI. So if they're receiving SSI, it could cause a loss of SSI and Medicaid. But the problem is, if they're not paying rent, they're getting housing for free, below fair market value. And if they get housing or food or shelter is the phrase that SSI uses, food or shelter for free or less than fair market value, they lose dollar for dollar their SSI, but only up to 1/3 of the total amount of their SSI. So SSI is 900 something, it's about 1,000. So they're going to lose about $330 of their SSI, even if they're living in a Bel Air mansion. They only lose that first third. Now, if they don't have any other reductions that month, they'll keep their Medicaid, because as long as they have $1 of SSI, they get their Medicaid. But if they had some other reductions, like they got some cash income, or they earned some income, which is reduced $1 for every $2 earned, and there's no cap on it like there is for food and shelter. If that happened, then maybe they would lose their Medicaid too. Now, if you're willing to have them lose that 1/3 of SSI, you may still want to put that residence into the special needs trust. Or if you know they are qualified for SSDI, you may want to put that residence into the trust. But you never want to put it in the beneficiary's own name, even though technically they can still qualify for benefits and own a home, because first of all, Medicaid will recover against anything that's in their name. So if you had a chance to put it in a third-party trust and leave it to somebody else after the beneficiary's death, you lose that if it goes into the beneficiary's own name. And then you also have to have management of that asset with a conservator or guardian if the beneficiary is not competent. So putting a residence into a third-party trust, absolutely do it if you know the risks and you advise your client and your client's trustee about the 1/3 rule for SSI. And I think are we up for time, Kyle?
I mean, we can go until 1 or as long as you want to go, but I don't see any other questions come in. So you're welcome to summarize with some final thoughts, or we can call it a CLE.
Well, I'll just invite, I think I have another page. I invite you to contact me with questions. And since I am the T&E section chair this year, I also invite you to contact me with topics you'd like to hear about, or presentations you think would be interesting for the section that you would be willing to make. There are only a couple spots left for talks, so contact me soon. And if you do email me, you might want to CC my assistant Melanie. She keeps me replying to everybody. And then if you want to talk on the phone or have a Zoom meeting, I'm willing to do that for my colleagues. And that's the second bullet point. Call Kelly, our receptionist, at that number, or email her, and you can schedule a Zoom or a teleconference for just a couple of minutes. And if you have any thoughts about this presentation, thank you for those of you who thanked me in the chat. I appreciate it. I spent some time putting it together, and I used AI for the pictures, not for the text, but those pictures were all AI generated using ChatGPT's DALL-E function. So you might want to get into AI. It's pretty fun. I think I'll close it there. Thank you.
Perfect. Thank you again, Deidre. And I will get the PowerPoint out to everyone after the fact, along with the CLE form. So if you have any questions, feel free to contact me, and I'll get the recording up as well. So if there's anything you missed or wanted to revisit, that will be on the YouTube page ASAP. And I'll get that link to you when I send out everything else. But thank you again, Deidre, for presenting today. And I hope everyone has a happy holidays.
Yes, happy holidays, everybody.
Bye, everyone.